Hi, my name is Benjamin Argyle. Good afternoon from New York. I see from our attendee list that you are all located all over, and our presenters are today as well. I'm an attorney in Venable's New York office. I straddle the commercial litigation group and the insurance coverage and dispute group. We also have here my colleagues Michael O'Connor and Heidi Rao. Michael is resident in our Los Angeles office and sits in Venable's commercial litigation and insurance groups. And we're very excited today to welcome Heidi from Venable's newly added Chicago office. Heidi is the Deputy Practice Group Leader of the new to Venable and highly renowned construction law group. Today's webinar is the second in a series of presentations hosted by members of our insurance coverage and disputes practice. Today we're going to discuss construction insurance, as you all know, for about an hour. Our next program is in May, and I'm very excited to attend it. Mike Davis and Mary Gardner will be joined by colleagues from Venable's preeminent tax practice to discuss the most interesting emerging trend in the insurance world, captive insurance programs. Details will be posted on venable.com, where you can also sign up for our emails and reminders for these events. But for today, let's jump in. Just to quickly look at our agenda today, Heidi's going to talk to us about sort of what construction insurance is, how it fits into a construction project, the building blocks of insurance, the types of insurance that is available for a construction project, and also give us an update on some interesting developments in the OSIP and CSIP world. She's also going to talk to us briefly about trends that we're seeing in the construction insurance market. Then Mike is going to talk to us about the exclusion that we're seeing a lot, being applied a lot to deny claims, which are the leg 2 and 3 exclusions, which are just a very interesting topic. And then I'll wrap us up with an update on what everyone wants to talk about whenever insurance comes up in today's world, which is business interruption insurance, and some interesting updates that have come out in that space as well. So welcome. We're all very glad you're here. And now I'm going to turn it over to Heidi.
Hello, everyone. It's great to be with you all, albeit under some somewhat strange circumstances. I'm excited to talk to you today about one of my favorite topics ever, which is construction law. But today specifically, we're looking at insurance. And I would just encourage you, if any of you have any questions throughout this program, feel free to use the Q&A feature at the bottom of your screen. And if time allows, we will try to get to all of those questions. So preliminarily here, we are going to talk about insurance, and we'll assume a certain working knowledge of some of the construction insurance and not dive too deeply into those, and then focus on some more interesting topics and maybe some traps for the unwary. But to start us off, let's talk about some of the types of insurance you would see on construction projects. You have your general liability policies, so your CGL and your auto. You have workers' compensation and employers' liability to cover losses associated with worker injuries. You have excess and umbrella policies that sit on top of general liability coverages. Professional liability, you may think, well, isn't that only for design professionals? Well, sometimes you will see that in construction contract specifications for insurance as well, with respect to any portion of the work that may be design related, such as design build scopes. There are certain special types of insurance that may not be required for all projects, but things like marine insurance that relate to transportation, both on water, but also on land, and also contractors' pollution liability for environmental risks. And then typically you'll have a builder's risk policy. Sometimes the owner maintains the builder's risk, sometimes the contractor does, but fundamentally that's property insurance that provides property insurance during an active construction project. Delay in startup coverage is often bundled with the builder's risk policy, but that covers losses associated with delay in completion. And then we have overall insurance programs, whether they be OSIPs, owner-controlled insurance programs, or CSIPs, contractor-controlled insurance programs, that provide coverage to all of the participants well, almost all, to many of the participants on a construction project, and as a way to provide a single source for insurance rather than having all of the project participants bring their own coverage. Lastly, some would argue maybe it's not insurance, maybe it is, but subcontractor default insurance, that is insurance that protects against subcontractor defaults. It is insurance that's maintained by the construction contractors, and it's an alternative to payment and performance bonds. It's payment and performance bonds also protect against subcontractor defaults related to either payment on the project or the performance of the party that is bonded. But subcontractor default insurance has become a popular alternative because some folks have found that it's a lot easier to recover under SDI as opposed to payment and performance bonds. And oftentimes people believe that the SDI responds faster than sureties do under the payment and performance bonds. So those have become another popular feature of insurance on construction projects. Moving to the next slide, what are some of the critical insurance provisions that you will want in your insurance specifications? This is just a quick little high-level checklist, but typically you, of course, want to specify the types of insurance that will be required for the project and the policy limits. You typically identify the duration that the coverage has been maintained. Sometimes there is insurance that needs to be maintained, should be maintained after the project is complete. So you'll want to specify exactly how long that would be. Oftentimes the duration to maintain some of this insurance is really commensurate with the statute of repose or statute of limitations for bringing claims. In other words, you want to have insurance that covers those losses for as long a period of time as those losses could arise and you could see claims from them. Additional insured, it's really important to specify who's going to be and who must be an additional insured on the insurance policies. Generally speaking, there are two ways of being an additional insured on an insurance policy. One is by means of an endorsement that specifically identifies you as an additional insured on a policy. The other way is by blanket additional insured endorsement. And those blanket additional insured endorsements typically say that anybody who the insured is required to name as an additional insured under a contract shall be an additional insured. So if the party you're contracting with has a blanket additional insured endorsement, you want to be sure that you have a contract with that party that requires you to be named as an additional insured. Otherwise, you may not have the benefit of that coverage. A separation of insured provision is also important. That's a provision that provides that the coverage applies separately to the individual insureds, and that can be especially helpful for things like your work exclusions and other exclusions that may preclude coverage to you or for you if that separation of insured provision isn't included. The waiver of subrogation, this allows insurance to respond to claims, but prevents parties from then later being sued by the insurance company who covered the loss, and provides nice protection for the project participants. And then finally, in some of the more sophisticated contracts, you'll see a provision that allocates responsibility for deductibles. Oftentimes the party that procures the insurance is the party that pays the deductibles, but sometimes you can get into different arrangements for how that's allocated. Especially I'm seeing it in the case of builder's risk policies, where the owner, for example, may procure the builder's risk policy, but doesn't want to be responsible for paying multiple deductibles if, for example, the loss was caused by the contractor. We actually had a circumstance where there was a high rise that was under construction. It was covered by a builder's risk policy. There were pipe bursts in the high rise under construction, and the pipe burst happened on multiple different floors. The insurance company argued that each pipe burst on each floor was a separate occurrence, and therefore that the insured must pay the deductible for each of those pipe bursts before insurance would respond. As you may guess, the amount of the deductible was actually less than the cost to repair on each of those floors. So it became a very expensive situation where the owner was potentially faced with covering the cost for all of these pipe bursts and did not have the benefit of insurance. Ultimately, we were able to work it out and come to an arrangement with the insurance company, but that's a circumstance where the owner felt that, at a minimum, the contractor should have had some responsibility because they were in part responsible for the pipe bursts. Looking specifically at OSIPs and CSIPs on the next slide, Benjamin, please. These are wrap-up insurance programs, and it's basically because the insurance program wraps the project in insurance, and as I mentioned earlier, it provides insurance for many of the project participants. There are certain notable exceptions. The design professionals are often excluded from these wrap-up policies, and that's because these insurance wraps oftentimes provide general liability coverage first and foremost, and sometimes workers' compensation. So the wrap-up policies will exclude the design team and will oftentimes exclude certain subcontractors, as well as some vendors and suppliers. But they can be a great benefit. There are some trade-offs. Some would argue that there are lower premiums if you're using a SIP, but higher administrative costs. Maybe it's a little bit more complicated bidding because rather than just having everybody bring their own insurance to the project and charge you for that insurance, parties are trying to figure out what kind of credit they will give to the owner because the owner is providing the insurance or maybe the contractor is providing the insurance. Maybe you have overall lower cost for the project, but is it maybe a higher cost for the contractor if they're trying to maintain their separate policies and trying to figure out how to give an appropriate credit for this project. While OSIPs and CSIPs can be very beneficial, there are some special considerations that sometimes people aren't really thinking of and can create some significant risk down the road. In an OSIP, for example, you may be part of a joint venture. In other words, the owner entity for the project may actually be a joint venture of two different potential owner-developer entities. In those circumstances, it's important for the parties to figure out what happens if the joint venture partner who's procuring and taking the lead on this OSIP defaults or goes out of business, or for whatever reason under the terms of the joint venture agreement may no longer be a part of the project. That can obviously be problematic because you want to make sure that your OSIP or whatever insurance program you procured for the project remains in place for the life of the project. And oftentimes you're paying significant deductibles up front. And so you don't want to pay a significant deductible on a wrap insurance policy or any insurance, and then later find out that that insurance isn't available. By the same token, if you have a CSIP, you have to think about what will happen in the event that you terminate the contractor. On one project that we encountered, the owner had retained a contractor for an $800 million plus project, and the contractor procured a CSIP to cover that project. The project was just barely underway when it became evident that there were going to be significant labor issues, tension with the unions and things of that nature. So ultimately, the owner decided it was in their best interest to terminate that particular contractor that was having issues with union labor and retain a new contractor. Well, they went ahead and did that and then expected that the CSIP would carry over. Well, as many of you may guess, that doesn't work because that CSIP was specific to that contractor. So they said, okay, fine, then give us a reimbursement on the very significant, and in this case, it was over $10 million premium that we have paid for this CSIP that is no longer going to provide coverage. And the CSIP carrier refused. So we have a project that just barely got off the ground. The contractor's been terminated. The owner has paid over $10 million in premium for the CSIP, CSIP won't be available and the carrier isn't reimbursing. So as you might imagine, that's when we got a call, and we were called in to assist with that situation. But really the lesson learned from that instance is really think about these things ahead of time. Write into your contract the procedure for what will happen in the event of termination. Will there be a reimbursement? How will that work, etc. Staying on the OSIP topic, there is a recent case that also highlights some of the risks associated with using wrap-up insurance. In this particular instance, and this is a very recent case, the opinion was published in February of 2021. There was a plaintiff, essentially the prime contractor was enrolled in the owner's OSIP. That contractor basically was acquired by another contractor who formed this new entity and assumed the construction contract where the original contractor had been enrolled in the OSIP. Ultimately, there was a loss. There were 2 job site deaths, and the contractor, this new contractor, was sued. That contractor, the plaintiff, sought relief and coverage under the OSIP, but the OSIP carrier denied coverage on the basis that the plaintiff was not enrolled in the OSIP. And so there was a dispute about whether the new contractor should have been enrolled. Of course, the contractor said, we assumed we were enrolled. You had enrolled the existing contractor that we had acquired. We had every expectation that we would be enrolled. We're entitled to coverage. Ultimately, this case has not played out through to its conclusion. But what was significant about this opinion, and what's a word of caution to everyone on this webinar, is that the court allowed the plaintiff to assert claims for defense and indemnity against the carriers, but they also allowed the contractor to assert claims against the owner for breach of contract, for failure to name them as or to enroll them in the OSIP, for breach of fiduciary duty, for tortious interference with a contractor, and estoppel as a result of the fact that they weren't named in the OSIP. So that, of course, is a situation that every owner would want to avoid, but also a situation that every contractor would want to avoid. So it's important that if you are going to use one of these tools, to make sure that you're properly following the protocol for the insurance programs. I mean, on that note, my practice largely focuses on representing project owners, and I'm seeing an increasingly high number of project owners entertaining the idea of OSIPs. And there's technically nothing wrong with doing OSIPs, and a lot of insurance carriers are touting the benefits, the project savings, and things like that. But just keep in mind that there is an administrative component to that. A lot of these carriers are selling their ability to assist with that, and that may be a benefit as well. I haven't seen that play out in full, but just keep in mind that even if you do have somebody assisting, you have to give them the proper information, make sure the proper parties are being enrolled, so that in the event that there is a loss, there is coverage to cover it. The other case we wanted to mention, only because it's relatively new, is this Liberty Mutual Fire Insurance Company case from January of 2020. And in this instance, there was a dispute between the OSIP insurer and a subcontractor's general liability insurer about which policy would respond. This was a condominium claim related to a defective roof. The subcontractor roofing contractor subbed out the roofing materials and the installation to a lower tier sub. That lower tier sub wasn't enrolled in the OSIP and had its own insurance, where the subcontractor was named as an additional insured. The first tier subcontractor was enrolled in the OSIP as well. So when the claim for defective roof came down, the subcontractor wanted coverage under the lower tier sub's general liability policy, but that carrier denied coverage on the basis of an exclusion that provided that there would not be coverage in the event that there was an OSIP. And in this instance, the court found that that exclusion applied to the first tier subcontractor, and that the general liability policy would not provide coverage to that first tier sub, notwithstanding the additional insured status. So to give my fellow colleagues here a chance to respond, I'll just quickly touch on some construction trends that we're seeing in the industry. You know, construction projects during the pandemic, they really persevered. Real estate deals took a hit. All of a sudden, they came to a screeching halt. But incredibly, the construction projects rolled on, especially those that had financing in place at the time the pandemic hit. Those pressed on. You know, even with the shutdowns, construction projects were deemed essential services. Construction workers were deemed essential workers, and things rolled on. Of course, parties looked to insurance for relief when the pandemic hit, and builders risk was really in the crosshairs, and I know my colleagues will speak more on that. But that didn't necessarily provide the answer. And now, even though the pandemic has, is hopefully subsiding, we're still feeling the effects, and we will continue to do so. There are some effects that insurance isn't really a good fit for, such as labor issues, where subcontractors, if they hear there's a positive case on the project, they may not want to show up at the job. Insurance might not help you much there. But the other thing we're seeing is steel prices, for example, going through the roof. You have supply chain disruptions, you have other material costs that are going through the roof. And so what some owners are doing, what some contractors are recommending, is that you buy some of these long lead items, oftentimes for two reasons. One, to make sure you can secure that material, and secondly, to sort of lock in the price and avoid some of the cost escalation. So my last point on that note is, think about your builder's risk insurance and make sure that your builder's risk policy, or evaluate at least, whether your builder's risk policy will provide insurance coverage for materials stored off-site. And one tip I got from a really talented risk manager I work with at one of my developer clients was, get that, if you know the off-site location where it will be stored, try to get that scheduled on the builder's risk policy to provide yourselves with that additional protection. So on that note, I will turn it over.
Thanks, Heidi. That was wonderful. It's always great. We're litigators, and we come in after things have gone wrong. It's always great to think about how could we have prevented this in the first place. I'm going to turn it over to Mike in a second to talk about the leg 2 and 3 exclusions. But first, I want to give the password for those of you interested in CLE. The password is construction 2021, all lowercase and no space between construction and 2021. Mike, over to you.
Great, thanks, Ben. I represent policyholders in connection with construction insurance claims. And so my clients are the owners, the general contractors, the engineers, and project managers. So if I have a bias in the remarks today in favor of policyholders, you'll understand where that comes from. I'm typically brought in when there's a disputed coverage claim in a large project. And my job when I come in is to marshal the insurance that's available and try to put together a patchwork of policies to provide the necessary coverage for the loss. And my first stop is the builder's risk insurance. And it really is the central policy that you're going to look to in any loss on a project, because while a particular claim may implicate general liability policies, may implicate professional liability insurance, those liability carriers are going to take a back seat until the builder's risk policy adjusts the claim. So that's going to be where you're going to look first. It also has broad coverage for basically all risks of physical loss or physical damage to the project. You can even add, as Heidi mentioned, some extensions of coverage for startup, delay in startup, contractors' extra expense, architects and engineering fees. But the main risk here is physical damage to property. It covers everyone, the general contractor, the subs, and a lot of other people that are providing on-site activities. And so everyone kind of has a common interest in going to get coverage under the builder's risk insurance. You're not trying to point fingers. You're not trying to prove someone breached a standard of care in connection with a project, which often happens. You have kind of a common interest here on the builder's risk. It also has the highest limits. I mean, the typical limits for builder's risk insurance, the declared project value, which in a large construction project can be several $100 million. You compare that with the limits that are available under a general liability policy or a professional liability policy, and you'll see that the vast amount of policy limits are builder's risk. There are really very few standard forms in builder's risk insurance. Each insurer and insured group has its own policy language. And I was recently brought in by a client to review their master builder's risk renewal program, and they were presented with two policy endorsements for leg 2 and leg 3 ensuing property damage coverage. I asked me to review them, and I told the client, I said, these aren't leg 2 and leg 3 endorsements. The language has been changed significantly, and the coverage is significantly different. So you need to look at the builder's risk policies. And that's particularly true if you're dealing with an OSIP, where a general contractor may be provided with a summary of the available insurance, but not have an opportunity to actually see the policy. So if you're a general contractor in that situation, get a copy of the builder's risk policy, review it with your lawyers, and make sure that you've got the coverage you think you're getting, because your own builder's risk insurance is not going to respond where you're covered by an OSIP, because your own insurance has likely got a wrap exclusion. So the builder's risk coverage that you're getting through the program is likely going to be all the coverage that you're going to get. So where do disputes come in? That's our next slide. Well, other than fortuitous events like a hurricane or a lightning or something like that, physical damage to a project is typically caused by alleged defects in material, workmanship, or design. Well, every builder's risk policy excludes faulty materials, workmanship, and designs, but includes some coverage for resulting damage. So that's the battleground. That's the fight you're going to have. What is the defect? What is the ensuing damage that would be covered? And recently, the most common exclusions and extensions of coverage that provide for this ensuing property damage are the leg 2 and leg 3 exclusions, which we'll talk about in a minute. And as Heidi has pointed out, there have been recent claims histories which have caused a lot of the insurers to tighten up on their adjustment of the builder's risk claims. And we're finding that a lot more fights are being dealt with on this battleground than we had before. So to the next slide. Insurers traditionally do not cover defective materials or workmanship. It's considered an inherent business risk. And I think that mindset is a bias that a lot of adjusters have when they're adjusting builder's risk claims. The idea is we're not going to let you get away with getting coverage for faulty workmanship. You should have done it right. And so there have been some various provisions, cost of making good provisions, that have dealt with this issue and provided that there is some coverage for ensuing loss, but not coverage for the defect itself. And in comes the London Engineering Group. This is a consulting body that was formed by some British insurers to promulgate some standards for this issue of what is a defect, what is ensuing covered loss. And they promulgated a series of endorsements, which we call leg 1, 2, and 3. And the idea was to clarify what's covered and what's not covered. And the way these endorsements do it is basically to tell you exactly that everything is an ensuing loss is covered except for, and then they very clearly say what there is. So starting with leg 1, this is very clear that the insurer is not liable for loss or damage due to defects in material, workmanship, design, plan, or specification. Very clear, no coverage, not very helpful. And in fact, this type of provision is very rare now in major projects. Really, this is something that you're looking in most projects we're looking at are leg 2 and leg 3, which we'll get to next. All right, leg 2. Basically, this is a common, and it's for some insurance companies, this is kind of the standard go-to endorsement that deals with ensuing loss. And the leg 2 endorsement says, if there is damage due to defective workmanship, design, plan, or specification, the only costs which are excluded are the costs to repair the defect immediately before the damage. So the idea is you take a snapshot of the project, and immediately before the ensuing loss happened, what was the defect and what was the cost of that? And that would be what's excluded. The next slide. Leg 3 is kind of the Cadillac version of this endorsement. It is something which a contractor owner will often have to pay additional premiums to get. But it's even more liberal in terms of what is being covered. Basically, this endorsement says that if there is damage due to a defect, that the only excluded cost is the cost to improve the original workmanship, design, plan, or specification to have prevented the damage. So essentially, it excludes the cost of betterment for the project, but otherwise covers everything else. The second paragraph of this endorsement, like the Leg 2 endorsement, makes it clear that it does not cover construction defects standing alone. In other words, a project is not damaged by virtue of the existence of a defect unless there is ensuing damage. And this goes back to the original concept that we, the insurance company, are not going to reward negligent contractors for doing defective workmanship, but we will pay for ensuing damage. So here is a summary of what the differences are in these endorsements. Leg 1 is basically no coverage for faulty workmanship or resulting damage. This is an uncommon form. This is not something we see due to the liberalization of these provisions. Leg 2 is no coverage for faulty workmanship, coverage for the resulting damage. But again, you look at the snapshot immediately before the ensuing loss and what was the defect, and that cost is excluded. Leg 3, no coverage for faulty workmanship, but coverage for resulting damage. And the only cost that is excluded here is the essentially the betterment, the cost to improve the original defect. So an example that's often used is a faulty wire causing fire to another construction building. Under Leg 1, no coverage at all. Under Leg 2, coverage for the damage to the building, but you deduct the cost to have replaced the defective wire that caused the damage. In Leg 3, there is damage to the building, which is covered, but the only cost that's deducted is if you had to improve the original wire so that you could have prevented the damage. So that's generally the way those provisions work. It seems very simple, it seems very straightforward, but of course in practice, nothing is that easy. All right. Now, despite the importance of the builder's risk policy to a construction project, and despite the importance of these Leg 2 and Leg 3 endorsements, which have become very common in policies in the United States, there are no cases in the United States that interpret Leg 2 or Leg 3, 0. There's one case in Canada that is interpreted a Leg 2 exclusion, which is a case called Aconia, and that's the next slide. The Aconia case is a Court of Appeal British Columbia case in 2015, and it dealt with a hospital where there were concrete slabs that were being poured in various floors that over deflected. So you ended up having kind of a concave spot in the middle of these floors that rendered them unsuitable. And the cost to repair those floors was enormous, and particularly since this was a working hospital, required the shutdown of several wings of the hospital and extensive cleaning, and it was an enormous cost. Now, the Leg 2 exclusion says you look at a snapshot immediately before the damage and determine what is the defect that's not covered and what is the ensuing loss that is covered. Well, in this case, the insurance company said, well, it's all ensuing, it's all defective work, that the deflection of the concrete was a manifestation of poor design, poor workmanship, and so there's no coverage at all. The Court of Appeals said no, said that there is no defect in the slabs itself. What was defective was the workmanship, the shoring, the fabrication that was placed to set the slabs. And had there been no defect in that shoring, then there would have been no damage to the slab. And so there, the court said, basically, there's no evidence as to what the cost of the shoring was. It was minimal. And therefore, there's going to be no deduction for that. And all of the damages are covered loss. So that's the way the court in Aconia dealt with it. I actually had a very similar case, almost identical facts to the Aconia case, dealing with a hospital, dealing with deflections of the concrete flooring and the shoring issues. And the insurance company, in my case, made all the same arguments that the insurer in Aconia did. And while we ultimately got to the right place, there really was very little case law to guide us, which made the adjustment process difficult because you're really just dealing with language and not really, in the case of ISO forms for general liability, where there's lots of cases interpreting those provisions, very little case law dealing with this. Finally, the next slide, not to mislead you, I mean, there are a number of cases dealing with cost of making good exclusions with different policy language, not the leg 2 or the leg 3, which are becoming predominant. But there are a number of cases dealing with exclusions that have variations of saying the defect's not covered, but the ensuing loss damage is covered. Those cases oftentimes, like the Acme galvanizing case in California, courts will say there has to be a separate and independent peril that comes in to cause the damage rather than the defect from the damage caused by the defect. And there's variations of that theme in a number of cases. But two cases to kind of illustrate this issue are the Leadcore case in New York, which dealt with defective slabs in an office building under construction. And the insured was dealing with an exclusion, which is quoted here, which is basically defective work is covered, but physical damage resulting from defective work is covered. And in that case, the insured was making the argument that, well, the inclusion of a defective slab into this building damaged the building, and therefore the cost of removing that defective slab is resultant damage. And the court says no, that the insurance company is right. You can't have the exception to the exclusion swallow the rule, and it's all defective work, none of it's covered. In contrast, in the Leadcore case, which is another Canadian case, this is a Canadian Supreme Court case, that dealt with a circumstance where a window cleaner was engaged during the course of construction to clean windows, and during the course of performing that work, scratched the windows and required replacement of all the windows. The insurers said, listen, this is all defective workmanship. It's part and parcel of what the window cleaners were doing at the time, and therefore it's all defective work and not covered. The court in that case, again, drew this distinction between what is defective work and what is resultant damage and said, well, the cleaning of the windows is the defective workmanship. So we won't have the insurers pay for the cost of recleaning the windows. But the damage to the windows, that's resultant damage. And so therefore that is covered loss. So, you know, these are types of cases that are not the leg 2 and leg 3 language, which is arguably a lot clearer. But these are cases that you will have thrown at you if you're the policyholder trying to get coverage for ensuing damage. So this is an area where there's little case law on the leg 2 and leg 3. There is a lot of cases that have some application, but arguably are not really directly relevant to the way that the leg 2 and leg 3 endorsements operate. So there is a lot of confusion out there, and it's an area that I think is ripe for some additional case law. So with that, Ben, I think that's the conclusion of my remarks, and I'll turn it over to you.
Thanks, Mike. So it's very interesting that, let me go to the next slide here. It's very interesting that we're talking about all these builder's risk claims that are triggered by physical loss or damage, and that's the issue in those last cases we saw, which is, you know, whether the physical loss and damage is ensuing or not. Let's focus on the trigger for coverage under builder's risk policies and really all property coverage policies, including business interruption, which is often sort of an add-on to a property policy. The trigger for coverage is physical loss or damage. And we have seen in the past year all sorts of people trying to get coverage under their business interruption policies and arguing about whether coronavirus and coronavirus-related shutdowns trigger physical loss or damage. In fact, almost exactly a year ago, every law firm in the country started pontificating about how this would come out, including this law firm, guilty. There are no COVID construction cases yet, but we do have a bunch of cases in the business interruption context talking about whether COVID meets this trigger. The policyholder side arguments are that you have a disjunctive in there. You have physical loss or damage, and therefore physical loss has to mean something different than a physical alteration to the structure of a structure of a property. Before the pandemic, there was very little case law. A handful of cases, we wrote about them on our website, from the 1960s to the 1990s as to whether toxic substances, mold, gases, smells, there was a New Hampshire case about smells, constitute physical loss or damage. Most of those cases went in favor of the insured. And we sort of thought that that is also how the COVID cases would go. The early cases that decisions that we saw come down from the courts did not go that way. They went in favor of the insurance companies. The insurance companies did a very good job of fast tracking cases with virus exclusions. And a lot of us were left with the impression that there just might not be coverage for coronavirus related losses under business interruption policies. Later cases are starting to come in favor of policyholders, and we just wanted to highlight a few of them today. This says 2020 on here, but this is a 2020. Oh, I'm sorry, November 2020. So let's talk about the JGB case. JGB owns a shopping center about 1 mile from the Strip in Las Vegas, and they alleged that the coronavirus is a physical object, here it is, that attaches to and causes harm to other objects. Now, from a legal perspective, the court is compelled to accept all factual allegations in a complaint as true when evaluating a motion to dismiss. So here, the court actually denied the insurer's motion to dismiss because it had to accept as true that the virus itself is a physical object attaching to the property. And that's how the court found that, at least for the purpose of a motion to dismiss, coronavirus could meet that trigger of physical loss or damage. The next case, Goodwill Industries, a very similar sort of stance. Again, the court had to accept as true this allegation that the virus is contained in respiratory droplets, it stays on surfaces, it physically alters the air and surfaces to which it attaches and causes them to be unsafe. So again, the court had to accept this as true. What's interesting about the Goodwill case is that there was pre-COVID precedent from California courts, and I'm looking down because I'm looking at it because the language is very important. Outside of the coronavirus context, there was precedent stating that, quote, direct physical loss, so again, loss, not just damage, but loss requires an actual change in insured property that is, quote, a distinct, demonstrable physical alteration of the property. So the Goodwill court had to wrestle with this. They couldn't, give the argument that many policyholders have put forth, which is that losing use of the property is enough to trigger physical loss or damage. The court had to look at whether there was a physical alteration to the property itself. And even in this rubric, the California court did say that the policyholder had met that standard because, again, it had to accept as true these factual allegations about respiratory droplets. Just going back to the JGB case, there was a pollution exclusion in that case, which is pretty interesting. There's very little case law yet about what courts are going to do with coronavirus in policies with pollution exclusions. In the JGB case, the court said that it is an open question as to whether the pollution exclusions apply only to traditional environmental and industrial pollution, not communicable diseases. And because it was an open question, the court did not dismiss the policyholder's case. So a lot of just interesting sort of tertiary issues that are driving a lot of these decisions. Turning to our next slide, we have the In Re Society Insurance Company case, which is a multi-district litigation pending in the Northern District of Illinois, which is where multi-district litigations go for the most part. And there are a lot of really interesting issues in this decision. So the policy in this case had an interesting trigger. So it's got the trigger for the underlying loss must be physical loss or damage. And then, oh, I don't know what's going on with my camera. That's strange, but here we are. Not only must there be an underlying physical loss or damage, the policy suggested that the economic loss in the business interruption separate coverage must also be caused by physical loss or damage. The insured argued that even if you meet the first trigger, that coronavirus triggers the physical loss or damage piece for the underlying damage to the property. The economic loss was in fact caused by government orders shutting down and restricting policyholders' use of the property. And so the courts had to look at it through this lens of, well, if I have the loss, but then I have an intervening cause of the government shutdowns that's causing the economic loss, is that enough to trigger? And the court said, you know what it is. There's no strict causation requirement here. In law school speak, it would be an approximate causation. That's not applicable here. If we have the trigger in the first place, if we decide that coronavirus can be considered a physical loss or damage to property, that's enough to also meet the second sort of prong of the argument that the court was looking at as to whether the economic loss is also caused by physical loss or damage. So it's interesting that we just saw all these cases coming in early on last summer and last fall in favor of the insurance companies. It's interesting the ways that policyholders are pleading their cases to get around those early decisions. Pardon me. It's also interesting the ways that courts are coming at these decisions. Let's see here. The last case I want to discuss is in a slightly different context. Soundview Cinemas versus Great American Insurance Group. This is a case out of the New York trial court down on Long Island, Nassau County Commercial Division. Judge Driscoll, very smart judge. And here we have, although the insurance companies are involved in the dispute, and that's why you see their name in the caption there, this decision is about the dispute between the policyholder and the insurance broker. The policyholder sued the broker on a bunch of claims, including breach of fiduciary duty, saying that the broker failed to procure insurance that would have covered business interruption insurance that would have covered losses from the pandemic. And the court granted the broker's motion to dismiss for lots of different reasons. I mentioned breach of fiduciary duty. One of the reasons that the court granted the motion to dismiss and ruled in favor of the broker is that the insured never asked for pandemic-related coverage. And the court also adopted the broker's argument that there was no coverage for this. So how could anyone have asked for it, and how could the broker have known to procure it? Whether that's true or not is a separate issue, but that was certainly the posture of this case. The reason this matters in the construction insurance context is that we are seeing a lot of litigation about whether there is business interruption insurance that meets that trigger of physical loss or damage. But in construction projects, there is often an obligation to procure certain types of insurance on behalf of other project team members. So it's interesting that this case says, if you have an obligation to procure insurance and your obligation is to procure insurance that probably doesn't exist, then you haven't breached your obligation by failing to procure that insurance. So it'll be interesting to see where this goes. This just came down a few days ago. We'll see if it gets reported and picked up elsewhere. I don't know where we are on time, but I think we're going to take a look to see if our technology is working for the question and answer. How are we doing, folks? Do you see anything that jumps out at you? Or should we give everyone 8 minutes of their day back?
Well, I do see one question that talks about the difference between being a named insured and additional insured. So just very briefly, I would say that the named insured is the primary insured under the policy. They get the full benefit of the policy. They're the owner of the policy. And the additional insured, by contrast, is somebody who's basically added to the policy at the request or the obligation of the named insured. And the key is that the additional insured likely has limited coverage under the policy. So again, talking about the contracting side of the world, if you are going to be named as an additional insured, many people just say, hey, be sure to name me as an additional insured and call it a day. There are many different levels of additional insured coverage. And so some owners will actually specify, or contractors for that matter on lower tier subcontracts, specify the type and scope of the additional insured coverage that's required. Oftentimes by reference to ISO forms, which are standard forms, insurance forms, that can be a good way to say, you must name me as an additional insured to the same extent as provided under IS form, fill in the blank.
Thanks, Heidi.
Yeah, and there's a question that came in for me about do builders risk insurers offer policies anymore that don't use one version of the leg exclusions? And the answer is yes, they still do. Although I think that for larger projects, these leg exclusions are becoming more dominant. And really, I think it's for the clarity that these exclusions bring, notwithstanding the absence of case law, which would be helpful. These provisions are much clearer in terms of what is covered and what is not covered. And so most of the renewals that I've seen of policies recently have been for a leg 2 or leg 3 exclusion. That seems to be kind of the business standard now. But yes, there are still policies that have cost of making good exclusions that are more kind of less specific and more of the traditional version.
Thanks, Mike. I see one more question here asking if we'll be circulating the slides. And yes, we will. They'll be posted on our website in about a week. And I think we're going to let people take 5 minutes of their day back. Thank you so much for attending. Come back in May to discuss captive insurance companies. And enjoy your day. Bye, guys.